I'm here sui juris in propria persona. I reserve all rights. I, Jonathan Troy Faithfully Colin Schuster, comma beneficiary and sovereign, and here under fraud, menace, and duress. Fiduciary. This is a Social Security Cesticate Trust action, which you are now a real party and interest to. I'm here sui juris in propria persona. I've challenged the jurisdiction of this court, and I don't understand. So I do need some questions answered. Is there a bond on this matter?
I believe you were PR. Actually, bail was set at $2,000.
There is a bond on this matter, correct?
Yes, there is.
Okay, and so is my social security number attached to these charges in any way?
I don't believe so.
You don't believe so?
I don't have any record of your social security number. So as far as I know, I don't know your social security number.
No, I'm saying is my social security number attached to these charges in any way?
Only in the extent that it's connected to your driving history.
So is that a yes or a no?
In some way, shape, or form, your social security number is in the system with records on you. That is true.
Okay, so you just told me there was a bond, which means this is commercial court.
It's not commercial.
Now you're saying that my social security number is attached to these charges. And so, which means this is a Cesticate Trust action, which you are a real party and interest to. And I just told you I was the beneficiary. You're supposed to be charging the trust. You're not charging the beneficiary. And if you're creating bonds against my trust without my permission, I don't understand. Are you...
Buckle up, guys, because right out of the gate this hearing derails fast. The defendant launches into sovereign citizen language, insisting the court has no jurisdiction while demanding answers about bonds and social security numbers. The judge stays composed, but you can feel the disconnect growing. This moment sets the tone. One side grounded in procedure, the other living in a completely different legal universe.
I'm saying that you are subject to the jurisdiction of this court.
This matter cannot move until you've proven jurisdiction, and you failed to do so. And if you cannot prove jurisdiction, then this matter needs to be dismissed with prejudice, because this is a commercial matter. I'm a non-U.S. citizen American national by way of American Samoa. I'm beneficiary. I'm here sui juris in propria persona, and we cannot move any further on this matter until this is either dismissed with prejudice or you can prove jurisdiction.
So what would you like to do with your case? I assume, Mr. Parent, that you are not representing?
So the man cannot speak for me.
Okay, he's not speaking for you, but I am asking him a direct question, so I need you to let him answer.
Okay.
Yes, so the court did appoint us on this matter, but it sounds like he does not want my office to represent him, so I'm happy to withdraw.
You can dismiss yourself.
So would you like to represent yourself in the matter, Mr. Schuster?
Please do not tell me to shut up. You can dismiss yourself.
So he can't dismiss himself, only I can dismiss him. I'm asking you if you wish to have an attorney or if you wish to represent yourself.
This is a trust or Cesticate Trust action. And so I'm here sui juris in propria persona. You know what that means. And so we can prove...
I don't know what it means because it's nonsense, but nonetheless...
Prove jurisdiction, or we can dismiss this matter with prejudice.
So I'm not going to do that today. Here are your choices. You can have Mr. Parent represent you. You can choose to obtain private counsel, or you can represent yourself. Let's start there. Which of those three?
Nobody's going to represent me. I can present myself, as I said.
So you wish to go pro se? I don't need you to read the script. I need you to tell me if you wish to go pro se.
I told you I'm here sui juris in propria persona.
Ms. Roberts, are you there?
Yes, Judge.
My inclination is to set this matter over and see if Mr. Schuster wants to give it another shot with his attorney or go pro se.
All right, guys, this is where the court tries to bring order. The judge pushes the defendant to make a simple choice: lawyer, private counsel, or self-representation. Instead of answering, he circles back to scripted phrases and imaginary legal concept. What stands out here is the patience of the court versus the defendant's refusal to engage with even the most basic legal reality.
It looks like this is the first pretrial. I suspect he's not prepared to set for trial today.
What is the first one? There's no plead. I've
Okay,
never-
I'm not speaking to you, so you're gonna have to wait. I'm speaking to Ms. Roberts.
I mean,
Judge, I would ask that we set this matter over 1 week.
And try again?
we can finish this matter now.
We
There's no
can't.
need to
We
move
can't.
this any further because
So here's
it's
the
not
thing.
proven jurisdiction.
Here's the thing. It's not my position today to have to prove jurisdiction to you.
It is. It is your position because
It's
it is
not.
on the courts.
And I'm also not going to argue with you.
There's no
So
argument.
I'm going to have you come back to court in 1 week.
There's nothing you can prove that you have jurisdiction. This man does not speak for me.
So we're going to come back to court on July 1st.
That doesn't work. That date doesn't work.
Why does,
With threats from your end, and I have no more time for this matter. And unless you can prove jurisdiction, there's no need for this matter to move any further.
you're going to come back on July 1st at 9 a.m. If you don't come back on July 1st,
Are you
then
threatening me now?
I'm telling you, there's going to be a bench warrant issued if you don't show
You're
up. So
threatening me now.
showing up
No,
or a
I'm
bench
giving
warrant
you the
issued.
choice to finish this matter now or be responsible for your actions.
We'll set this for July 1st. I'm
Would you
going
like to be responsible for your actions and set this further? Because you can do that, or you can dismiss this matter with prejudice.
I'm not going to do that today. So July 1st, 9 a.m. back.
You violated my rights enough.
We'll just hold Speedy for this
You
week, Ms.
violated my
Roberts.
rights enough. This matter needs to be dismissed with prejudice.
We'll see.
Now things heat up. The judge schedules a new court date, and the defendant reacts as if it's a personal attack. He frames accountability as coercion and treats lawful procedure like a threat. This exchange captures the core conflict. The court asserting authority and the defendant interpreting every consequence as oppression rather than responsibility.
Or else what? You're going to threaten me?
Or else the court will issue a bench
So
warrant.
you're threatening me now, Abigail.
I am telling you your
I'm telling you
options.
this matter needs to be dismissed with prejudice because you cannot prove jurisdiction. This is a
Signature
separate
here.
trust action.
Signature here,
You're trying
please,
to
sir.
commit fraud.
Sir,
You're
Mr.
trying to commit
Schuster.
fraud. Yes, I'm
So-
speaking with Abigail.
You're done.
No,
you're done.
you can't tell me I'm done.
I
This
can.
is no, you don't have power to do that.
Your court case is over.
You don't have power to do that.
Sir, your hearing is over. If you don't take your paperwork and leave the courtroom, we'll have you remanded into custody.
You're threatening me now,
I'm
even more
giving
so
you
than
a
you already
choice.
were. And if anybody tries to touch me, I'll charge them with assault and battery. So I will be gone because this matter is dismissed.
This clip is pure tension. The hearing is over, but the defendant won't let it go. When the judge warns about removal and custody, the power dynamics become crystal clear. This is the moment where courtroom authority stops being theoretical and becomes very real, exposing how far defiance can push before consequences follow.
That's Jonathan Schuster, 480525748.
For the record, this man.
Why don't you come up to council table, please, so we can create a record?
No, I don't want to give you any personal jurisdiction, so I'll stay right here.
No, you'll come to the council to be heard and make a record. So you need to come up and turn on the microphone.
No, I don't need to do that for me to be heard.
We are audio recording, so to be heard, you need to come up to the table and sit with the microphone.
You don't have to, I don't have to come up. You can hear me perfectly fine.
I can hear you, but we are creating a court record, which is audio recording.
Jurisdiction by doing what you said because you don't have jurisdiction over me. And so, for the record,
Mr. Schuster, I
I
did
reserve all rights.
put Mr. Parent as standby counsel. Right now, you don't represent yourself. You have standby
Appoint
counsel.
counsel to me
Well,
without my permission. He has no permission to be my counsel. I am here sui juris, appropriate persona, Jonathan Hyphen, Troy Faifuleo Somalia Toa, Colin Schuster, am here under fraud, menace, and duress. I've made a special appearance.
Alright guys, new hearing, same resistance. The judge instructs the defendant to approach the table to create a proper record. He refuses, claiming jurisdictional violations. What's powerful here is how something as simple as sitting at a microphone turns into a symbolic battle over control, legitimacy, and compliance with court rules.
To this court for those reasons. I've challenged the jurisdiction of this court, and you have not answered that challenge, Ms. Jennifer. And so I have some questions for you. Answer them.
I am not here to be interrogated by you. You are
Well,
under
I
the
just don't
jurisdiction
understand
of this.
what's going on here.
I think you understand and you choose not to
I do
take
not
in the information.
understand
Okay, well,
what's going
Mr.
on here.
Schuster,
I don't understand the nature and cause of what's going on. I don't understand how you can practice law from the bench. I don't understand how you can appoint counsel when I've told you over and over and over again that I'm here sui juris in propria persona. I'm here of my own right, in my proper person. He does not have my permission to represent me in any way.
well, it doesn't sound like you know how to represent yourself either, which you would,
represent myself.
well, you would. Either you have counsel or you are acting pro
Represent
se.
myself. Like I have told you, I'm here sui juris in propria persona. I have challenged the jurisdiction of this court. You have not answered that challenge. We cannot move any further until you've answered that challenge. Is this common law jurisdiction or is this an admiralty maritime jurisdiction?
Right.
Mr. Schuster, this is Carmen McDonald. I'm the prosecutor on this particular case. I think where we're at right now is you're being charged with an offense. I can barely hear you, which means the record that you're trying to make is not being picked up and not being recorded. So everything you're saying is not being preserved unless you go to the table up there near the microphone. So that's number one.
For the record, I reserve
If you
all
would
my
like-
rights. If you would like,
I will
step up so you can hear me better, and I will
none of
speak
it's being
louder.
being
I will
preserved.
speak louder.
Here the defendant delivers a long, uninterrupted declaration filled with legal-sounding phrases that mean nothing in practice. From the outside, it's clear he believes repetition equals power. The judge listens, but the gap between confidence and competence is glaring. This part shows how self-assured confusion can stall an entire legal process.
So you can hear me, but I reserve all my rights. And I'm speaking much louder than anybody else prior to me has spoken.
Mr.
So I just
Schuster,
want to make sure the
Mr.
reporter can hear
You
me.
are making legal arguments. All right? You are making legal arguments. They should be preserved for the record, which means it needs to be picked up and recorded.
I will
So-
begin again so that the recorder can
Not
hear me.
choosing to be silent, you're choosing to make a legal argument. So we need to have that on the record.
For all rights.
You've made that.
I, Jonathan, Troy, Faisal, Leaso, Maliatoa, Colin, Schuster, have made a special appearance under fraud, menace, and duress. Fiduciary, Jennifer. I've challenged the jurisdiction of this court, which has not been answered. This is a Social Security Sestake trust action, which you are now a real party in interest to. This is a military admiralty jurisdiction under maritime law. However, you must realize that you have no such jurisdiction without also having a valid international contract in dispute. I am not aware of contracts, so I deny that any such contracts exist. Will you please instruct the prosecuting attorney to inform the court if there is such a contract? And if so, place it into evidence and
This is where the prosecutor steps in and reality finally pushes back. The defendant demands proof of an international contract, and the response is straightforward. You entered a social contract by driving on public roads. This moment matters because it cleanly dismantles the fantasy with plain legal logic, even if the defendant refuses to accept it.
Don't understand. I think it's you choose not to understand and that you have someone giving you information that you are spewing in court. So you're simply off base, but I don't know that it's effect
we cannot
that is
move
causing you
forward.
to not be able to
to
understand.
challenge my competency because I have challenged the jurisdiction of this court,
We're
and you have not proved
Not dealing in
jurisdiction.
social security or contracts
You
or
have to prove
maritime.
jurisdiction.
So that's just not how it works in this court, and
No,
I don't think
that's
you
how
have
it
the
works.
legal.
You must prove jurisdiction because I have challenged the jurisdiction. If you cannot prove jurisdiction, then I move to dismiss this matter with prejudice.
That's denied.
And so, can you prove
I'm Judge Grant, so I'm going to
Jennifer,
have you.
can you establish the jurisdiction? Can you prove jurisdiction?
Ms. McDonald, I don't know that this is him not understanding
I do not understand the nature or cause.
Well, he doesn't have legal training. So that I think is.
That does not matter.
Well,
If I'm here sui juris and propria persona, I'm of my own right. I'm in my proper person. You've created a bond on this matter. You've attached my social security to this matter. You're trying to charge my trust without my permission, which is illegal. It's fraud, and I'm not going to stand for that. So you must prove.
Now the court shifts focus to competency. The judge makes it clear this isn't about intelligence, but about willful refusal to understand. From an observer's view, this is a critical turning point. The court is documenting behavior, not debating ideology, laying groundwork for what happens next if defiance continues.
Prove jurisdiction before we can move any further. You've already tried to practice law from the bench, which is illegal. You cannot do. You've tried to assign counsel when I've given no power of attorney to anybody. And we cannot move further until you
think would be the next steps. I don't know if Mr. Parent, have you been able to provide any assistance to him on a standby basis?
No, Your Honor, he doesn't want any assistance. I'd asked him to withdraw his
So we could go through the colloquy. We can provide him with forum for rights. I don't know that he's going to choose to participate in that. But that would be the next step and set it for trial. So Ms. McDonald.
I'm setting it for trial. If he's going to waive counsel altogether, then I think we need to have him sign the.
This part is procedural but important. The judge and attorneys discuss standby counsel and waiving right. Meanwhile, the defendant rejects all assistance. Watching this, you see the system doing everything possible to protect his rights, even as he actively sabotages his own defense.
A waiver of right to counsel.
Absolutely. I'm just saying I don't know that he's going to participate in that process either.
Right. No, I understand
We have
that.
speedy trial at
It is
August
the burden
9th.
of the state to prove jurisdiction. The prosecuting attorney has not done that. And so what we have here is we need to dismiss this matter. With
Denied. Denied.
based on the fact that the prosecuting attorney has not proven jurisdiction.
Mr. Schuster, would you like to sit at this table away from council so that we can hear you on the
This isn't
microphone?
counsel.
Well, you could sit at this table if you'd like. There's a pen and a form and a microphone.
You have failed to prove in jurisdiction.
Jurisdiction is something that we prove at trial. It is a factual issue as well.
We cannot move any further until jurisdiction has been proven. And none of you have done that.
Schuster, did the court say that was end of August, or?
It was August 9th is speedy trial.
So
And if you plan on having me back here, you're taking away from my ability to provide and work.
Well, I'd argue that you're the one taking.
Here the defendant doubles down, demanding dismissal with prejudice. The judge explains that jurisdiction is not a magic word you chant away charges with. This exchange highlights a hard truth. Courts don't operate on belief systems. They operate on statutes, facts, and process, no matter how loudly someone objects.
I cannot just be coming back here because it takes my time away from working. And so if you want me back here, it seems that you have Zoom port available. I'm more than happy to make a special appearance via Zoom, but you're taking away my time and freedom to provide for my family.
does the August term start August 6th, Your Honor?
It does.
So I would request we set it during August term.
Been charged with driving while your license was suspended in the 3rd degree and for operating a vehicle without the required ignition interlock device and refusing to comply with law enforcement officer. You are on a deferred prosecution in another court, and the consequences are extreme for it, and they could very well.
Get in trouble, and you have to prove jurisdiction. You haven't done that, and you've failed to do that.
This is one of the most grounded moments. The judge clearly lists the charges and explains the real-world consequences, including jail time. For a brief second, reality breaks through the noise. This clip matters because it shows the seriousness of the situation stripped of theatrics.
I believe that courts do have jurisdiction over you.
Obviously, you have to be able to prove it, and you haven't. and you can keep pushing it and doing this, but it's just a waste of time for everybody. I definitely understand that this is not what you think it is. And this is just a waste of time at this point. Due to prove jurisdiction, but I know you can't. So if you want to waste more of everybody's time, go ahead, because obviously I'm not going to allow you to threaten me anymore, which you've done.
Nobody's threatening you.
Yes, you're telling me if I don't appear, that you're going to put me into captivity. And that's ridiculous for what's going on here. That's absolutely ridiculous.
I don't think
This matter
anyone
needs
is
to be
told that you're being
dismissed with
put into
prejudice. And
captivity.
whether we need to take this to trial or whatever y'all need to do to prove jurisdiction, I mean, go ahead. But obviously you can't prove jurisdiction. So
I'm looking for the
defendant argues that court dates interfere with his ability to work and provide. The judge responds by pointing out that repeated violations created this situation. From the outside, it's a sobering reminder that personal hardship doesn't erase legal responsibility, and ignoring that only makes things worse.
more
waste everybody's
detailed
time, please.
counsel
Waste everybody's
waiver.
time. It's absolutely ridiculous.
I don't know that he's done that yet,
No, he hasn't. I have a streamlined version, but I want him the formal.
the detailed one. And we can also, Your Honor, just set it for trial today with an intervening pretrial, provide him with that document and enter the waiver at the next hearing prior to allowing counsel to withdraw.
Counsel should have never been appointed because I've never gave my power of attorney to this counsel. And obviously you did that to practice law from the bench, Miss Jennifer, which is illegal. You cannot do that.
Mr. Schuster, you're charged with a crime that has no consequences and fines, and so your rights need to be protected. This is for your benefit.
There is no injured party. There is no sworn complaint of an injured party. This is absolutely ridiculous. It's a waste of everybody's time. And you're taking away my ability to work over and over and over again. Then, okay, you're proving that you don't have any jurisdiction.
So this is a detailed advisement should you wish to waive your right to have counsel present and you want to act as your own attorney.
I've said over and over again that I'm here sui juris.
This case is going to be going to trial, so you need to have counsel.
I'm here of my own right and my proper person. You know what that
So
means.
there's the form.
I've
for you
never
to-
signed my power of attorney away.
This segment shows complete breakdown. The judge sets the trial framework, while the defendant accuses the court of rights violations. It's clear now that progress is impossible without compliance. The court isn't debating anymore. It's managing disruption.
To anybody, especially this.
You need to be respectful. You are really out of
I
line,
said
Mr.
this. I
Schuster.
didn't say anything disrespectful.
You are being
This
very
person-
disrespectful.
Disrespectful, actually,
the court
because
and to Mr. Parent.
you're violating my rights.
So I'm
Forcing
going
me
to set this on for the
come in here
August term. I'm going to have you take this
and
form.
Waste time.
Mr. Schuster.
When you're taking away my
I'm going-
ability to provide and work. Because
Have a
this is
seat there so
free-
you can fill out
free
this
place.
form.
What's that?
You can have a seat there so you can fill out the form.
You're dismissed. Do you need anything else?
Yes, I do. I need you to take that form. So we're going to have to go through that because this case is going to be going to trial. It's going to be set on that would be August 6th, and that will be at 9 a.m.
Here's a reality check moment. The defendant tries to leave, and the judge stops him cold. You're not free to go yet. From an observer's perspective, this reinforces that courtrooms are not optional conversations. Until the judge is finished, everyone answers to the process.
Right now, it's getting set for
You can't
trial.
move any further until you prove jurisdiction.
And the readiness hearing will be July 31st, and that will be at 2 p.m. And that hearing, Mr. Schuster, is on Zoom.
Any jurisdiction over me whatsoever. I've not pleaded. I've not given you personal jurisdiction.
Yes.
And you practice law on the bench
So, Mr. Schuster, if you choose not to come to your court hearings, a warrant,
Telling me
yes,
if I don't
you will be
play your
expected
game,
to appear.
And you just said yes. Oh my goodness. That if I don't play your game, you will put me in captivity. This is ridiculous. Absolutely ridiculous.
Yep, these are jailable offenses, but for this
Absolutely
hearing,
ridiculous.
we need your presence to appear for him.
Absolutely ridiculous.
What's the date for the intervening retrial?
Could you back there?
We can set
To provide any contracts that I've entered into internationally,
Here's your court date. Could you please sign? for that?
especially if this is an admiralty maritime jurisdiction, which obviously by the gold fringe flag it is. So
Mr. Schuster, you are in a criminal court and there are court rules. If you wish
criminal
to
matter, this is a criminal matter, you said?
Mr. Schuster,
Criminal matter?
if you wish to have discovery, then you need to abide by the rule.
Criminal matter?
Yes, and if you wish
Yes,
to have,
these are-
Oh, okay. I wasn't sure. You said admiralty maritime jurisdiction?
no, we are not. Mr.
Are we under
Schuster.
a common law? What jurisdiction are we under?
We are under the criminal jurisdiction of the state of Washington. So if you wish to have discovery,
Alright guys, this final clip ties everything together. The judge explains criminal jurisdiction clearly, outlines discovery procedures, and warns about warrants for failure to appear. The defendant still resists, but the court moves forward anyway. This is how the justice system ultimately works. Beliefs don't override the law. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next video.